Good evening and welcome. I'm Diane Meyerhoff, host for tonight's candidate forum for the Democratic primary for Chittenden County Assistant Judge. Tonight's show is being aired live on Channel 17 and streamed live on the Channel 17 website. We welcome your comments and questions. Please join the conversation at 862-3966. Candidates joining me tonight are Suzanne Brown.
Hello.
Charles Delaney, the incumbent. Connie Kane Ramsey, also the incumbent, and Zachary York. Thank you all so much for coming tonight. We appreciate it.
Thank you.
The ground rules for tonight's forum are the candidates will make opening statements of up to 2 minutes each. They will then answer prepared questions, also for 2 minutes each, with a possible rebuttal. We will go in alphabetical order. So for our opening statements, we'll start with Suzanne, followed by Charles, Connie, and Zachary. So Suzanne, tell us why you're running, what qualifies you for the position, and what your priorities are for the 4-year term.
Thank you, Diane. Thank you for hosting this forum. Ladies and gentlemen, I'm Suzanne Brown, and I am an attorney. I've been practicing family law for over 30 years, primarily in Chittenden County, but as well in other counties. I'm also a mother of 2 sons who I've raised in Vermont, and I'm a proud grandmother of Piper. And I should tell you that I, too, have been divorced and have had that experience in Chittenden Family Court and understand the stress that people go through, especially when it comes down to issues of custody and parent-child contact. Assistant judges play a major role in family court as well as in other areas, but they do assist the judges in findings of fact, which the judge can then use when doing his or her opinion. I'm also a Rotarian. Rotarians believe in service above self, and I have been president of the Colchester Milton Rotary and have won many awards for my community service. I've been on several other boards. I've been on a board for Hadassah, and I'm on the board for a local synagogue, so I'm familiar with budgets and dealing with lots of people. Family court is such an important role for people who are going through divorce and parentage cases. And I believe that we need knowledgeable and thoughtful people there to assist the judge in making these very important decisions. I'm also very well aware of case law and statutes which change from time to time. It's not a common sense decision. You really should be familiar with the changing Vermont case law to be able to be of assistance to the court. So I welcome this debate, and thank you for having me.
Great, thank you so much. And we are actually going to interrupt our opening statements because we have a call.
Already?
We do, we have a call. Hi, you're on the air. Maybe not. Do we have anybody there? Line 1? Oh, wait, let's try to unhold him. There we are. Hi there.
Hello.
Hi there, you're on the air. Do you have a question for the judges?
Hello?
Yeah. Yep, you're on the air. Maybe they're not hearing me. Okay, why aren't they hearing me?
Hi, I have a question
There we
for Suzanne Brown.
Okay, we'll have all
Yes,
the
I have a
candidates.
question for Suzanne Brown.
Okay, we'll have all the
Or
candidates.
should I ask for all of the
Yes, you should ask for
all
all
of
of
the
them.
judges?
Yes, yes, thank you. Please do that.
Hello?
Yes? I think we're not working. Sorry, guys. All right, let's go back where we were. Charles, opening statement.
I'm Charles Delaney. I'm your assistant judge in Chittenden County. I'm an incumbent. I'm running for my 3rd term. I've been here since about 2010. Part of our job is administrative, maintain the county budget at current levels, which is about around 0.5%. We're allowed to go up to 5% without going to the voters. But I think in terms of being responsible to the taxpayer, we've tried to keep a budget intact. At times we've had to find ways to create revenue to do that. And with things changing, we're still doing that. In the meantime, we have kept up on case law. We were certified in civil mediation, special court jurisdiction, and uncontested divorce. We had to go out of state for this to the National Judicial College in order to do this. And I'm proud to say, in terms of keeping the public in mind, we did it through foundation grants. It didn't cost the taxpayer money, being mindful of the administrative part of this job. I've had experience in shepherding bills through the legislature. In doing that, it had to do with a lot of civil right law. In 2007, that was done, and again in 2010. I helped write the criteria for tribal recognition in the state of Vermont as chair of the Vermont Commission on Native American Affairs. That put me in the purview and work with the committees in the legislature. In doing that type of work, I was able to see how laws are passed, but really getting the intention of what the lawmakers had behind law in order to do that. I also participated in 2014 in the judicial restructuring in the state.
Okay, I'm going to stop you there, Charles. Thank you. Connie, opening statement, 2 minutes, please.
Okay, thank you for having us, Diane, and we're happy to be here. I'm happy to be here. So I'm running for my third term for assistant judge. I'm the co-assistant judge with Judge Elaney, and we've had 8 years with only positive feedback for me and for him as well. I think it's very important to have family and local experience in this job. We spend a lot of time in family court, and I was born and raised here, and I know the community well. When the judges rotate, they are not familiar with the area necessarily, so assistant judges are the local connection to the area. I think I have 2 kids, Polly and Taggart, and I raised them with my husband Jack, and so I've got that family experience. And then when Judges Crowley and Grudkowski retired in 2010, I decided to run, and they helped me to get this job, and other people helped me, and it's been going well. And since then, I've got 8 years experience in the judiciary, sitting in family court, civil court, and maintaining our civil court properties, Chittenden County properties. 8 years of training by the different State of Vermont, Judicial College of Vermont, and National Judicial College. I'm dedicated to helping our community's families. There's a lot of vulnerable people out there, and they wind up in court because they can't afford their homes, and they can't afford, the cost of living just keeps going up, and they can't figure out ways to increase their income. And I'm also dedicated to make sure the people who are being abused are protected
Okay,
by the
I'm gonna
courts.
stop you there. Thank you. Zachary, tell us opening statements, please.
Sure. My name is Zachary York, and I'm a Democratic candidate for County Assistant Judge. I was also recently nominated by the Progressive County Committee for the general election. I was born in California, and I lived in Central Vermont, where I grew up in Montpelier, Barre, and Cabot. I graduated from Spalding High School, and then I went to Burlington College, and I graduated with a bachelor's in legal and justice studies and a certificate of paralegal studies. I learned under a lot of local attorneys during that time. Adjunct professors are primarily practitioners, so I learned with many people who were experts in their field, and I feel like that was a great education. And that's when I first learned about assistant judges, because part of my family law course was to sit in on relief from abuse cases to learn about how that system worked. And the system's actually becoming more and more overwhelmed. To a lesser extent, these stalking and sexual assault cases in the civil division are also having an increase. I believe that my training in college, my training in general pursuit of education in the rest of my life, and my experience has really lent me to be an excellent candidate for this position. What's great about this really unique Vermont position is that you get to be a layperson judge. You don't have to be a lawyer. You can sit in on cases and not make a judgment based on the facts, based on the law, but you make a judgment based on the facts. So whose case is more persuasive, which affidavits are more informative, what is the most compelling evidence. So that's especially true in cases where there's disputed facts. So one side has an affidavit saying, these are the list of things that are true, and the other side has an affidavit saying, we disagree with those. This is the list of things that are true. And when they have to have a hearing on those, it's essentially who has the most plausible case. And I feel like with what I've learned and what I've grown up with, I would be an excellent candidate to do this.
Great, thank you very much.
Thank you.
Thank you all. We're going to go into our prepared questions. Again, there'll be 2-minute responses. And don't forget, we'd love you to call in 862-3966. So tell us, we're going to start off with Charles. We'll have you be the first person. What's your approach to running an efficient and effective county courthouse? Because we've learned that is part of the job of this assistant judge. And how do you evaluate your results?
If you're talking about the administrative end first, that would be, we come up with yearly budgets for the different departments. And I have to say that, it seems to be a rigorous process in doing that. It's an uneventful affair, really. We get maybe 3-4 phone calls from the different town clerks wanting to know if the budget's gone up or not so that they can prepare their town budgets. In that sense, it's pretty cut and dry. In terms of the maintaining a budget, it takes 4 of us to sign checks and pay the bills. So, it's a good balance in terms of knowing the bills are paid, how much is paid, following the budget. There's no play in that since there's 4 people and all those sets of eyes looking at it. In terms of the courtroom itself, I feel that it's a traditional role in the state of Vermont. Since day one, we're in the state constitution. It was designed for lay people, and the reason for that was that they wanted a person from the community who knew the local officials, who knew people in the community, to be able to have a better understanding when people came to court what was going on, and to be able to be an ally in that sense for them. We discern the facts. In certain roles, such as relief of abuse orders, there comes a degree of preponderance in it also. And in knowing our community, I think we have a more educated sense of what's going on. We all have to agree on the facts before a state judge can make a legal decision. So I think, in looking at it that way, it's like a small jury. And it creates another form of balance. The state of Vermont is almost unique in this. There might be one other state that has such a role in doing it. The reason why the forefathers wanted lay people to do this job was because they had a distrust first of the king and the prosecutor, and then in early state government and federal government, there was mistrust.
I'm going to have to stop you there.
Thank
Sorry.
you.
You can tell us in the next question. Okay, we are talking about running an efficient and effective county courthouse. Connie, you're up.
Well, thank you. It's been running well for 8 years. Like Judge Delaney was saying, we work up a county budget. We ask the sheriff department and the probate department, and we look around the courthouse and see what we need to do for the year, and we stick to that budget really well. And we hire good people to work for us. We've got Ann Williams as a county clerk, and Christopher Danaher as a buildings and grounds contractor. And then we hire John Letty as a county treasurer. And we do a lot of delegating. We give them goals and we let them do their thing. We had some of the last goals were to make the courthouse more friendly. So we painted the walls and put up some interesting stories for people to read, and made the passport office kid-friendly. And we, of course, the main thing we have to do is make sure that the courtroom is working well, the lights are working, and the heat is working, and all of that. So, and we are very good at keeping to the budget. I'll say that. When the checks are written, there are 4 of us that have to sign off on them, so that there's no problem with that. And all of our citizen and professional input has been positive over the past 8 years. So things are going well.
Great, thank you. Zachary, tell us, how would you run an efficient and effective county courthouse?
Sure. So it all begins with the building itself. A lot of it has to do with the county buildings proper. So that is the sheriff's office, which needs some work, and then there's the county court itself, which is on Main Street in Burlington. It's a big, beautiful federal building that was then given to the county government many years ago. In my opinion, a lot of it has to do with ensuring upkeep of the buildings. We have very old buildings that need, preventative maintenance and maintenance that we plan in advance for to make sure that, there are no unexpected surprises. When it costs thousands of dollars to run the air conditioning every month, you want to make sure that everything's going to be working ahead of time. It's also important to make sure that the county sheriff has everything they need. So is the building up to code? Do they have enough space for all their vehicles? The county deals with hundreds of thousands of dollars going to the sheriff's office, and is it being spent adequately? So I feel like my education, my experience would lend me to be a good judge of how those funds are being spent and if there's a better way to allocate them.
Okay, great, thanks. Suzanne?
Well, I'm going to answer this question from a different viewpoint. We all understand that there has to be a courthouse and other buildings that are up to code and bills paid, and I don't feel that I'm sure that we can learn about the budget and so on, but what's really important is there's not enough time to handle all of these cases in family court. Family court is being overrun by people who, for many reasons, don't have attorneys, or maybe they can't afford attorneys, and so they're trying to do their own cases. And it takes a lot longer for that person to present their case, if they're capable of doing it, than if they had an attorney. How do we address the overage of cases in family court right now? I think we need to do some training. I think that it would be great if we had the Chittenden Bar once a month volunteer and go staff a clinic or an informational session that is open to the public if they are going to be in family court, so that they can learn some important things about what is important in a custody case, what's important in a relief from abuse case, what do you need? If we have more educated consumers, I think it would help decide those cases. Number two, what about for the attorneys who are trying these cases? Well, there's a thing called a case summary form. And I have used this many times myself as an attorney handling all these types of cases. I would not need any training if I had this position. But rather than having a protruded 3 or 4 day trial, you can have attorneys fill out these forms on different issues. They're presented to the judge to read a few days before the date, and then you meet with the judge and the assistant judges, and you get what's called a weather report. Now, unfortunately, for some reason, it seems that the court is no longer using these case manager forms. So if they were to, these case summary forms, if they were able to do that, you will find that more cases will settle and resolve, thus freeing up more time for the court.
Stop you there, thank you. We have a question, and I think we'll dive, this is perfect timing actually. So what kind of relationship should assistant judges have with unions? Does it imply a bias if an assistant judge or candidate endorses a union? Okay, and we are going to start with Connie.
Well, I have to be very careful. I wouldn't be in a union because that's bias, and you have to be very careful to not be biased in this job. I don't know what else to say about that. We're not allowed to even endorse. I can't endorse a candidate. I can't give money to a candidate except for a fellow assistant judge. I can't go to a rally. I can't do anything as an assistant judge. That's one of the problems I have with being an assistant judge. I love being an assistant judge, but that is one thing that I have had to live with, because you can't do anything like that. It's in the canons.
Okay, Zachary.
So I feel like this question is coming for me because I'm a proud union steward and I'm on the legislative council for my union. I've been a member of the VSEA, the Vermont State Employees Association, for several years. Well, not several, but a few years at this point. And I don't think there's a problem. I don't think there's a problem at all. Being an assistant judge candidate does not lend me to not be in my role as a lawful political activity. So, I certainly think that it is perfectly acceptable for me to be in a union position. I consult numerous different articles to govern my activity, including the union contract, which I have bargained for and fought for, and I will continue to defend for my coworkers.
Okay. Suzanne?
Well, once you become an assistant judge, you're not allowed, you're not, I know, once you become an assistant judge, you're not practicing in any other position. That is your full-time job, from my understanding. If I were to have this position, be elected to it, I would stop my legal practice and devote my full time to this job. And I'm not aware of how a union impacts at all how the cases are tried and the decisions are made. So that's my opinion on that.
Okay. Charles, union activity.
As assistant judges, lay judges, we're still under the same canons as the state judges. And I would imagine anybody who's running for this position would fall under such rules too. We can't endorse unions, we can't endorse institutions, candidates for other positions. Those things are reserved probably for other candidates and other types of positions. If a case came in front of me, be it a union case, I would have to, and I took a stand before that, I would either have to recuse myself or not be involved with it to begin with, not to show in proper court. And I think that we have to be mindful of this position, whether we're running for it or whether we're sitting in it now, not to show bias. That's part of the canons that I have to follow. It's not a matter of personal opinion about what I think about an institution or a union. But if cases come in front of us, we have to show in proper judgment, and we can't impugn the court. Once that's done, then there could be appeals and the like. So in order to do our job, we have to steer clear of these things and keep our opinions to ourselves.
Okay. Thank you. And thanks for the caller, wherever the question came from.
Could I just add something?
Everybody can have another minute, sure.
Okay. Just to clarify, I've been a union steward and on the legislative council out of pride for my coworkers, out of pride for my job, out of pride of being a state employee. And if being a judicial candidate and a judicial officer conflicts with that, obviously I would step down. I am well aware of what you need to recuse yourself with when you are in a situation as a judicial officer. If you are a relative of one of the parties in a certain extent, or if you have a prior relationship with one of the parties. For an example, one of the judges I work with, he informed the parties in a case that 20 years ago he represented one of the parties, a corporation. Was that a problem with anyone in the courtroom? And it wasn't, so the hearing continued. So I'm well aware of being a judicial officer means recusing yourself from things you would have a conflict with, and I would be prepared to do that.
Okay. Suzanne, do you want another minute?
No, thank you.
I do.
Charles first. Another minute or no?
I'll pass.
Okay. Connie?
Well, I think it's great that you're doing the work for the unions, but the canons state that you're not supposed to show bias in any way, and most people would resign before announcing their candidacy. So anyway, that's what I think. Like, you can recuse yourself, but it still shows bias.
Okay, let's move on. Do you support the use of mediation as a way to resolve disputes outside of the courtroom? And we're going to start with Suzanne, you're going to start.
Yes, well, several years ago, the judges were given the authority to order, this is the main judge, to order mediation in cases. And quite frankly, I think mediation is a good idea in certain situations. It seems to work very well in parent-child contact cases and in custody cases. You can take all of the antagonism and the problems that the two parties are having together and take it out of the situation, have them meet with someone who knows certain family law principles and have them discuss more calmly what they believe is in the best interests of the children. So, and I personally have mediated and have had my clients go to mediation. There are, however, some cases that are not necessarily good for mediation, in my opinion, and that has to do with the issues of financial support, which is called spousal support. I have found that typically when women are asking for spousal support or seeking spousal support because they don't have earnings significantly to support themselves, that they don't fare as well in mediation as they would in court. So I don't advise clients to mediate that type of issue. There is one thing you should be careful though, however. If there is a relief from abuse situation where one party is intimidating the other party and they feel they can't represent themselves well and they're intimidated, that is not a good case for mediation.
Okay, great, thanks. And Charles, we're talking about mediation.
As of July 1st, 2017, state judges were allowed to suggest mediation for certain cases. I think mediation generally is a good idea because it empowers the people involved to come up with their own decisions for their own conflicts, as opposed to a state judge saying this is the decision. It allows input, real input by the people involved. On the county level, we got certificates in civil mediation, and so did the assistant judges in Franklin County. We had a bill in place so that one suggestion was that maybe they could go down to the hall and discuss and agree to a mediation and to try and facilitate that. Another bill that was done was H 849, which is to help alleviate the burden of all the court cases that we have, for assistant judges to do status conferences, reset family motions hearings, those things. And it's been difficult, mainly from the state level and from the attorneys, because they see it as a power struggle between lay judges and state judges, when in fact we could really help people who can't afford attorneys, who have a hard time in court not understanding the process. We can be there for them if we're allowed to. And this is something that we'll continue to work with and make these changes as we go forward.
Okay, great, thank you. Connie, use of mediation.
I love mediation as a way to have families solve their disputes. It's much better to have them working things out on their own and through compromise and all of that, instead of having the court impose restrictions on them. If they can work it out themselves, then it's much better for them to follow. They've had some input into it. And the court system is really a last resort. So we have started in the past year, we can actually order people to go to mediation. And then if they still can't work things out, or they can work out most of their problems, and then they can come back to court for the last few things. But hopefully they can work it out all, because court should really be a last resort and not anything further. And like Judge Delaney was saying, we did go to Reno and get 40 hours of mediation training. So we don't use that because that also is against the canons, but it's nice to know how to do it anyways, because it teaches you how to talk to people, and it's useful. So thank you.
Okay, thanks. Zachary, use of mediation.
So I believe that mediation is incredibly important, especially in civil cases. Oftentimes what's happening is local attorneys are just emailing back and forth, and they've never actually met each other. We have quite the saturation of attorneys in Chittenden County, which could be a blessing, but also has attorneys who never really interact. So getting people face to face with a mediator is actually very useful. I, for the past few years, have been in charge of the foreclosure and landlord-tenant dockets at the judiciary in the civil court, and I have been referring cases to foreclosure mediation that whole time. A law changed a couple of years ago after the financial crisis, where people, if they're the primary, if it's their primary residence, they're entitled to request foreclosure mediation. And if they don't request it initially, they can request it later, even up until after a judgment order issues. So it's really a fantastic system. I couldn't speak more highly of the Vermont Bar Association, which coordinates the mediation service with us, and the attorneys who are mediators do really wonderful work. It saves a lot of people's homes, and it saves a lot of people a lot of heartache, and I couldn't endorse it more.
May I have a response?
Absolutely.
Doing this job for 30 years, I know that 9 out of the 10 cases that a lawyer has typically are settled. If the lawyers were to try every single case that they had, it would be impossible to get court time. So we have this small percentage of cases that, for whatever reason, the attorneys with their clients try to work on an agreement, and they're not able to do that for some reason. I find that when the clients know what the factors are that are important, let's say, in a custody decision, then they can go and mediate and understand how to make their case, so to speak, to the mediator. The mediator is not there to inform the clients of their rights or of the law. The mediator is there to get the parties to agree. So there takes a lot of preparation many times for these parties to go to mediation, and I've had many successful results where I thought the parents would never agree, let's say, to a shared custody agreement, and the mediator was able to pull it off. But I want people to understand that you really can't mediate without knowing the important legal statutory requirements that would affect a custody or a relocation case. And if you mediate without knowing that, you're really hurting yourself.
Okay. Charles, do you want to say something further about that?
To me, it's not about necessarily a technical aspect of the law. It's about the understanding of how people feel, what they feel that they have to gain or what they feel that they're going to lose, and to be able to address that directly with people so that they are comfortable enough to talk about that in a setting towards a resolution of a situation. Most people, especially the ones without attorneys, they're not thinking about the law. They're thinking about, how can I get through this? How can I keep my home? How can I keep my child? Those types of things. And yes, there's a financial aspect to that. But to have people understand that, you can do this, come up with your own decisions if you're able to mediate it. A mediator is basically, to me, is an organized referee. And to be able to make both parties feel comfortable enough to be able to at least discuss their point of view about it and to come to a resolution so that they can have a stipulation and come to court and say, we agree on it, the judges sign off on it, and it's a beginning, not just an ending for people, but a new beginning. And if we can do that for people, it's the best resolution possible.
Okay. Connie, do you want to say something?
I just have a little story about that. There was a mediation case, and they could decide everything except for who got the family dog. And so the Judge Katz, it was Judge Katz, he said, okay, who wants the family dog and who has the children? And children were with the mother, and the father wanted the family dog. He goes, okay, you go talk to your client and tell him that he needs to call his son and tell him that the dog is not coming home tonight. And so he went and told his client that and came back and he said, we have an agreement. So just a little, anyway, I thought that was a nice story.
Okay. One sec. We're just going to let Zachary have a chance at a further rebuttal of this.
Just to add that one of the other things that the Civil Division does is in complex cases that require a lot of discovery, which is the parties gaining information from each other before the trial happens, they fill out these forms called Alternative Dispute Resolution reports. They're called ADR reports. And what they do is they set out a timeline for when discovery will be completed, when motions that would dispose of the case for one side or the other would be filed, and when the trial ready date would be. And they also have a time for when mediation would be completed. And I think this is just a great practice. I'm very happy that the mediation statute is the way it is, and I think it should continue.
I just want to make a point, if I may.
Sure.
That just because, and I'm really gearing this towards family court, I've seen this many times. I just want to get my case over with. I just want to get out. I can't take this stress. Just because the parties have an agreement doesn't mean that the agreement is fair and equitable. And in fact, the judges have a legal duty to review agreements to make sure they are fair and equitable. And let me tell you, I have seen some judges, and in some points, not you, the assistant judges, but prior assistant judges actually say, I've reviewed this agreement, I don't think it's fair, and they have not accepted the agreement, and they sent the parties back to either get some legal advice or to renegotiate, so to speak. An agreement on its face doesn't make things fair and reasonable.
Charles, do you want to say anything more?
Yeah, I mean, most state judges on occasion will send it back. But as assistant judges, you know, this is where we've come in. We don't argue these things in front of people from the bench. Usually, sometimes we have some very interesting conversations in the chambers about these things, about what is equitable, about what is fair. Is this the right thing to do? As opposed to what the legal terms are in it. And at times, you know, we've had vocal arguments. This is the reason why assistant judges are there. If two assistant judges disagree, we can overrule the state judge, and they cannot make a legal finding on it. And that happens on occasion, not all the time. But the chambers and these conversations do persist. Part of our job, too, is that we do read the dockets. We do read the stipulations. We do understand that who the parties are involved and what's at stake. And we take that, looking at them as people, about what is the best possible outcome. Not just for them, usually there's children involved. And in spite of the arguments that the parents, the adults are having, what is the best outcome for the children? You know, these are the real stakes.
Connie.
I was going to bring that up too. The best interest of the children is kind of our mantra, and that's what I would be most concerned with. And I think most mediators know that. They would only accept or negotiate something that was in the best interest of the children, hopefully. And maybe once in a while something squeaks through, but it needs to be tweaked a little bit. But I think mediation is wonderful. I think it's great. And when people can work out their own problems and set their own visitation schedules, it works out better for everybody.
Exactly.
I'm a child of a divorced household, so I'm well aware of relief from abuse cases and domestic divorce cases. So just from the child's perspective, I definitely got an education in that when I was very young. I thankfully was treated very well by the courts. I was treated very well by both parents, and everything is very good now. But I think the family division is one of the most difficult divisions to work in because it is the most personal I think it is one of the most personal at the very least, because it is someone who you are blood with, who is now wronged you in some horrible way, and how do we move past this in an equitable manner? And I believe my experience would be helpful.
Great, thank you. We've actually talked about pretty much all the questions, I think, at this point, but I'm going to ask them anyway. We'll go back over them. We talked about some people cannot afford attorneys, especially in domestic cases such as divorces and issues with children. How how can you help people better represent themselves? And I know we've talked about mediation for sure, so that's one we have there. But are there other things that you could imagine doing in your 4-year term? And I wanted to be clear too before I ask that question, is that there are 2 seats up. We have 4 candidates and 2 seats, so you'll vote for 2 boxes when you go to the polls, because sometimes that's not always completely clear for folks. So I want to make sure that people know that.
And we're not running against a probate judge.
And you're not. That's tomorrow night. We're going to talk to the probate judges.
Some
so
people
yes,
think that we're
separate.
running against
Yep.
Greg Glennon and
Yeah,
Bill
so we have
Norfolk,
2
but that's
separate.
not
We have
true.
the assistant Chittenden County judges, and then we have the probate judges. And there's only, I think, one probate judge or 2?
There's one
One.
probate
One.
judge.
Okay, so there's 2, you guys, and one of the other. Okay, so just so we have that clear for everyone who's watching. Okay, so we are going to start with Charles. Tell us how you think we can help people better represent themselves.
There are some other institutions out there. There, Vermont Law Line, such organizations that can be helpful. I think that there's also training that can be involved in relief of abuse cases. As an example, there's a STEP program. It's called. It used to be Women Helping Battered Women. Before that, they come to court on Thursdays in family court, and sometimes show up on Wednesdays in civil court stalking cases. And their some experience of just being in the courtroom and seeing is helpful to the clients involved. I do think it would be further if they did get help from the Chittenden Bar Association. They're advocates in terms of the sense of being there for the person in the court, so they're not steamrolled, so that they're not fearful. But to have a better idea of what the idea and the intent is behind this would be most informative for these people. To me, this is a vacuous thing. What do you tell somebody who doesn't have an attorney, who has just a basic idea of what their right is? Most people want to be heard in court. And if they feel like they're stifled or they weren't able to get their side of the story out, I think that's a failure of the court system. And I think that, anything that we can do to help people feel more secure in themselves and in their own rights as a person, a human being, to come forward, to be able to say these things in the courtroom would be most helpful. Because it's not always what's said, it's what isn't said.
Okay. Connie, how we can help people better represent themselves?
Well, I try to help them at the pretrial conference. Some people will think they don't know the rules of evidence, and they'll think that they can enter a letter or something like that. And I'll make sure that they know. I don't always tell them, but I pass a note to the presiding judge that they can't, they have to have the person there to testify. They can't just, Suzanne knows what I'm talking about. They can't just bring the letter in. Because that could be, that's hearsay. Could be from anybody. The other thing is, if they're at the pretrial conference, make sure that they know what the threshold is. Like, if they want to change their visitation schedule or they want to move and bring their children with them, they need to prove a real and unforeseen change of circumstance. And they don't know that sometimes. And that's what they need to prove before they can change anything. So I'd like to see if I can make sure that they get all the information they need. And it's on the website. Maybe if they did a little homework, they'd be better off, but a lot of people don't even have computers. They're, so anyways, I try to help them in any way I can.
Okay. Zachary, how to help people represent themselves better?
So the thing I can draw on the first is, in my time with the judiciary, I've run the landlord-tenant docket, which is a very quick-paced docket where you have landlords who haven't been paid rent in months, and you have tenants who either couldn't pay or the place wasn't habitable, so they haven't paid. One thing that a state judge did was she sent out a letter to the bar and she said, we want to have people come in and have a clinic. We have all these rent escrow cases. It's the most likely hearing for these people to show up at. Why don't we have members of the bar come in with members from Vermont Legal Aid, Lawline, Vermont Volunteer Lawyer Project to sit in on these 10, 15-minute hearings and advise the litigants of what is happening, what this means if they fail to abide by the escrow case, and what the ramifications would be. They also argue if the litigant says, this place had bugs and it was mold and it didn't have any heat. If it wasn't habitable, then they don't need to pay rent for it. There are statutes that govern this. So I couldn't commend, this was Judge Helen Torr who did this, I couldn't commend her any more for starting this program. She recently started it up in Rutland County a few months ago, Addison County before that. I don't see why we can't have a program like that for relief from abuse cases. Not necessarily representing them in court proper, but maybe having a clinic ahead of time. Right now they have a video system where you go in and you sit and you watch a video explaining the proceedings, explaining who the judge is and what each side does. And you also have advocates there, which is very helpful. But why can't we have an extra step? I think we can do more.
Okay, and Suzanne.
Here's a novel idea that hasn't been tried in Chittenden Court. And it's been tried in Franklin Family Court, and I'm sure there's other courts that have done this with regard to family problems. There's so many people who cannot afford an attorney, and what if we had reach out to the bar, to the attorneys, to say, we would like to get volunteers to come once a month from a set period of time to talk to people who are having some cases in family court and try to give them some general advice, try to answer their questions. This is done in Franklin Family Court, and it's a very effective program. Why it's not in Chittenden Family Court, I don't know. It's not in the bylaws of what an assistant judge should do, but certainly we're not precluded from suggesting this type of program and reaching out to the bar. I'm a strong proponent of that. I've done a lot of cases pro bono, meaning that I'm not charging. I've also given free consultations to people so that they can help themselves in court if possible. And I'm reaching out to the bar here to say, step up, try to help some more people who don't have an attorney and give them some advice, because these are the most important decisions of their life: custody, contact, finances, and that is my idea.
Thank you. We've got a time for a quick one more question, and then we'll do closing comments. So I'll give you about a minute. This is yet another activity of a side judge, is the participate in setting the budget for the Sheriff's Department. So tell us, should that continue to be a job of the side judges or not? And we're going to start with Connie.
Okay, well, we've been doing it ever since I've been there. And the sheriff is a county entity, and we house them. We pay for their department building, and we pay for their training, and we pay for their heat and all that. And I think it's appropriate because they do good work for us, and they protect us, and they do prisoner transport. And I think it's only right for us to support them in some way. They get other money from the state, and they have contracts, so it's not just us that give them money. We don't give them very much money. I mean, it's just a small part of our budget, but we do give them some money.
Okay. And we have a question from the audience, so we'll take a quick break here, and please.
Hello. So I was at a local political gathering, a county candidate gathering last week, and the two incumbents were there. And they were speaking about their job, and it was fairly well received. And then the probate judge mentioned that he sits in cases with them and was very happy with the performance. And a lawyer in presence also sort of mentioned the same thing from the other side. So I guess specifically for the two challengers, maybe what was the impetus, and what do you think you bring to the table that's not there already in this position? And maybe sort of the same question for the incumbents. So what do you bring to the table that's not there already?
Great, thanks. Zachary, we're going to start with you for a minute, please.
Sure. So I am, like I said, I graduated with a bachelor's in legal and justice studies and a certificate of paralegal studies. So I have a lot of experience with reading the law. I understand this is not a law reading position, but I would certainly bring that perspective. I think more than anything, I don't think I have anything bad to say about anyone on the stage. I wish them all well. I just think I am an excellent candidate for this position. I think I would be good at it, and I think I would enjoy it. I do what you love kind of thing. I couldn't think of something that would interest me more every single day. So in my current work, I read affidavits, I read motions for summary judgment, et cetera, and I have to figure out what we do with them and when they're ripe and what happens next. And it's only logical to me to also then go into the judicial capacity. Why not? This is something that I can do without going into tens and tens and tens of thousands of dollars in additional student loan debt. And it's a way I can serve my community, and I would really enjoy it. Thank you.
Thank you, Zachary. Suzanne, you're next.
Well, I guess I have the most legal experience in court, and that's where this job is at. It's in court. I do practice other areas besides family law, but that has been my primary focus. And I didn't go to law school the conventional way. I have a master's degree in education, and I've done various other jobs besides being a lawyer. But I found that this is a great way to help people. And unfortunately, I have seen cases where perhaps the outcome or the decision was not fair, was not equitable, was not correct. But the parties don't have enough, or a party doesn't have enough money to appeal it to the higher court. And so they are so-called, they have to abide by that decision. I don't think knowledge of the law hurts a person in doing this job. I think it helps a person understand all the different parameters that you have to look at, and in asking questions of these witnesses and of the parties to get to the prime issue, what should be done for a parent-child contact schedule.
I'm going to stop you there.
Thank you.
Charles?
This position traditionally and was made for lay people. The candidates running, they're learned people, but it was also life experience put into this. And it was exactly that, to come up with fair ideas of what is fair. As an example that was brought up, parent-child contact, parental rights and responsibilities. These are things that we deal with day in and day out. It's not just the law that's involved, it is a preponderance. What would be best in this situation? That's why we're there. That's the job that we do. We try to be a more human aspect to a courtroom setting, which is all about the law and procedure. And that's why we're there.
Okay, great, thanks. Connie?
Well, I think what the questioner was alluding to is that everything is going well, and why change it? So I agree with that. I think things are going well, and if you get somebody that they don't get along with, the two assistant judges have to get along, or else there's trouble. Historically, it's been a very bad thing, and we get along. We're very different people, but we work it out. We see things from different points of view sometimes, but it works. It works very well. And there's no really reason to change. I think we should just keep it the way it is. And we've gotten glowing reports from everybody that we work with, the courtroom people, the lawyers, the judges. Everybody's happy with our performance. So I think we should keep things as they are.
Okay, thank you. We have another question from the audience.
Yes, this one's for Suzanne Brown, and I wanted to know if, how you feel with your legal experience as an attorney. Your experience is important for this position. How do you feel it's important for this position as assistant judge?
I would like to tell the audience listening that there have been other lawyers who served as assistant judges and have done the job well. And knowing how to get certain points across, to make your case clear, to negotiate, these are all things that I have done in my 30 years of legal experience. And quite frankly, there's always room for improvement, and there's always room to try some new and different things. I too have been supported by many of the judges and my clients saying, gee, I'm so happy with your services. Have you ever thought of doing something and becoming an assistant judge or a judge? So while I respect the jobs that the incumbents have done, it can be better.
Okay, I think we're going to talk about the importance of legal experience for the job. Charles.
I think the legal experience, if we're talking strictly about that, came from my life experience. I shepherded a couple of bills through the legislature. I was not elected. I was appointed chair of a state commission on Native American Affairs. 2007, it was S-117 that we shepherded through, and it had to do creating Abenakis as the original minority. That way they could receive federal Indian education and health monies. That was the start of that. Later on in 2010, S-222, which we came up with a criteria for tribal recognition, which ended an argument about who an Abenaki was on the state level between people and on the tribal level in terms of membership. It ended all these arguments. And there was a lot of racial arguments that came involved in that from the greater public. And it ended these arguments. And it was a way to go forward in a positive manner. And in dealing with these things, that's why I came back home, Chittenden County, was able to do this on a family court level and in civil court. And I'm doing the same things today, practically, in working with a smaller group of people, judges, court administration, and the rest of it. I wish that they would allow us to do more. When I've suggested the bills, and it include landlord tenants also, they wonder why assistant judges want this kind of power. It's not power. If we can assist the state judges in doing these things in a courtroom setting, the clerical work, that gives state judges more time to write their findings. We are overwhelmed.
You there, Connie.
And the question was,
It was about the importance of legal education experience in this work.
oh yeah. Well, that can sometimes be a problem. In 1994, an assistant judge was elected, and she was a lawyer. And the term starts in February, so it's 1995. She started in February 1st. And within a month, there was a petition from all the assistant judges all across Vermont to have her removed. I don't know what she did, but I'm not saying that will happen with you, but within a year, she was gone. She had to resign because of the Supreme Court ended up getting involved and all of that. It can be, if you can take your lawyer hat off and just stick to the facts, then I think it would work out, but that might be hard to do sometimes. Anyways, that's what I have to say about that.
Okay, we'll come back if you want, but let's go to Zachary.
I think legal education in this position is important, but it's, as the Constitution states, it's not necessarily a requirement. The assistant judges are in the statute, they're in the Constitution as layperson judges, so I think it's valuable. It can only be an asset. I'm not aware of what happened in 1994 with that assistant judge, but I find it difficult to not have a benefit from having someone who has some legal education on the bench in this layperson position. I'm well aware of there have been 28 assistant judges in the state currently, and I'm not sure how many of them are lawyers, but I believe the majority of them are laypersons, and if there were issues, then I'm sure it would come to light. I don't really have anything else to add to that, I suppose.
Suzanne, I'll give you a half a minute
Okay, I
because we're running out of
can't
time.
imagine that knowing what factors go into making a custody decision wouldn't help in helping to figure out what facts need to be brought up to reach that threshold. I've received a lot of encouragement and praise from many judges whom I appear before because I've done so many difficult and contested cases. And if it was common sense, you wouldn't have laws, you wouldn't have statutes, you wouldn't have case law. It's more than common sense. And we are there to help make this process perhaps less emotional, a little bit smoother, a little bit more efficient. And I am certainly proud of my many years of legal experience, plus having used the system myself in going through a divorce. Thank you.
Okay, great. Well, unfortunately, we don't have time for closing arguments, or closing statements. Sorry, I've got the lawyer thing going. I apologize for that, but we had questions from the audience and phone. That's great. I'm really glad that folks are able to call, and we really appreciate your calling in. Want to remind everyone, you can vote now, vote early at your municipal or a city or town hall, or on primary day, which is Tuesday, August 14th. And again, thank you all so much for joining us tonight, and
Thank you for
appreciate
having
having
us.
Thank
Great,
you.
thank you.
Thank you
Good night.
very much.